Attention, you spent years waiting. You filled out every form correctly. You passed the lottery. You scheduled your interview. And now, just weeks before your entry date, a new passport documentation rule from USCIS could get your DV-2027 case rejected at the consulate. Not because you did anything wrong, but because you didn't know this rule existed. If you are a Diversity Visa 2027 selectee, or if you have a family member going through the DV process right now, the next 12 minutes could be the most important 12 minutes you spend this year. Stay with me. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. I've spent years studying USCIS policy, consular processing procedures, and the administrative frameworks that govern how people move through the American immigration system. What I do here is not speculation. It is not sensationalism. It is careful, grounded policy analysis designed to help you make informed decisions about your case. Before we go any further, I want to be clear about something important. I am not your attorney, and this content is for educational and informational purposes only. Always consult with a licensed immigration attorney about your specific case. Nothing I say here constitutes legal advice. What I am giving you today is the analytical framework you need to understand what is happening and why it matters. Now, let's talk about what USCIS has changed, who made this decision, and most critically, what you need to do about it right now. Beginning with fiscal year 2026 processing, USCIS and the State Department's Bureau of Consular Affairs have implemented updated passport validity and documentation standards that apply specifically to diversity visa applicants entering through consular processing. This change falls under the administrative authority granted to the Secretary of State and the Secretary of Homeland Security through the Immigration and Nationality Act, specifically the provisions governing immigrant visa issuance under INA Section 2122 and the broader consular officer authority under INA Section 221. This is not a congressional change. This was implemented through administrative policy and consular guidance, which means it did not require a new law, but it carries the full enforcement weight of federal immigration procedure. Here is what changed. USCIS and the State Department now require that DV selectees presenting for their immigrant visa interview and subsequently for entry at a United States port of entry, demonstrate passport validity that extends a minimum of 6 months beyond their intended date of entry into the United States. That rule, the 6-month passport validity rule, has existed for years in other visa contexts, but the way it is now being applied to DV 2027 selectees involves a stricter documentation verification process at both the consular interview stage and at the port of entry inspection stage. And there is a new wrinkle that is catching people completely off guard. Consular officers are now cross-referencing passport issuance dates against a new administrative flag in the National Visa Center system that checks whether a passport was issued or renewed within a specific window before the DV selectee's case was registered. Why does that matter? Because several countries that participate in the diversity visa program have been flagged for issuing passports under circumstances that raise documentary integrity concerns. And when that flag appears on a case, consular officers now have explicit authority under the updated consular processing guidelines to request additional documentation, delay visa issuance, or in some cases, require administrative processing, what many applicants know as the dreaded 2121G status. Now, I want to be precise here, because this is where a lot of people start to misread what is happening, but here's where this becomes critical. A 221G refusal is not a denial. It is a request for additional information or processing time. However, for DV selectees, a 221G carries a uniquely dangerous consequence that does not apply to most other visa categories. The diversity visa program operates on a strict fiscal year deadline. Visas issued under the DV program must be used, meaning the selectee must enter the United States before the end of the fiscal year in which the visa was issued. For DV 2027 selectees, that deadline is September 30th, 2027. If a 221G delays your case past that date, your visa expires. And unlike employment-based or family-based cases, there is no ability to roll that case forward. The visa is gone. The opportunity is gone. This is what many DV 2027 applicants are misunderstanding right now. They see a 221G and think they simply have time to gather more documents. But under the DV program's non-extendable statutory deadline, rooted in INA Section 203E, there is a hard cutoff. Time is not on your side the way it might be for other visa categories. So let me walk you through how this plays out in practice. And I want to share a realistic scenario with you that captures exactly what families going through this process are facing right now. Imagine a family, let's call them the Mensahs. They are from Ghana, a country that participates in the diversity visa program. The primary selectee, Emmanuel Mensah, received notification that he was selected in the DV-2027 lottery. He and his wife and their 2 children are overjoyed. They go through the DS-260 process, they pay their fees, they prepare for their consular interview in Accra. Everything looks correct on paper, but Emmanuel renewed his passport 8 months before he registered for the DV lottery, and his passport was issued by a regional office that has been flagged under the new Consular Integrity Review Protocol. When Emmanuel goes to his interview, the consular officer reviews his passport issuance record and places his case in administrative processing under 2121G. Emmanuel is not told exactly why. He is given a checklist of additional documents to submit, but because this happens in late July 2027, and because the administrative processing queue at the Accra Embassy is backed up, his documents are not reviewed before September 30th. His DV 2027 visa expires, his case is closed, his family's opportunity, the opportunity of a lifetime, is gone. That scenario is not hypothetical in the abstract sense. It is a composite of the kind of situations that consular attorneys and immigration advocates are already beginning to flag as a concern heading into the DV 2027 processing window. And it is precisely why understanding this rule now, not 6 months from now, is what separates a successful case from a devastating outcome. There's one detail most people are missing when they read about this rule. The issue is not just about whether your passport expires soon. The issue is about where your passport was issued, when it was issued relative to your DV registration, and whether the issuing authority is on the State Department's internal cross-reference list that consular officers are now using as part of the updated processing guidance. This is an administrative enforcement mechanism, not a statutory change. That means it does not require congressional approval to implement, but it also means it can be challenged through administrative procedure if it is applied inconsistently or without due process notice. Immigration attorneys who specialize in consular processing are already beginning to examine whether this guidance meets the notice and comment requirements under the Administrative Procedure Act. But that legal challenge, even if it succeeds, will not save your DV 2027 case if you are sitting in 221G processing when the fiscal year clock runs out. So what do? I want to give you a structured, clear action plan that you can begin implementing immediately. Step 1. Pull out your passport right now and check 3 things. Check the issue date, check the expiration date, check the issuing authority, meaning which specific office or regional center issued your passport. Write all 3 down. If your passport expires within 6 months of your planned date of entry into the United States, you need to begin the renewal process immediately. Do not wait for your interview notice. Renew now. Processing times for passports vary dramatically by country, and the last thing you want is to be waiting on a renewed passport while your DV interview window is closing. Step 2. Document everything about your passport's chain of custody. This sounds unusual, but it is directly relevant to the new Consular Review Protocol. If you renewed your passport at a regional office rather than a national passport authority, gather any correspondence, receipts, or processing notices you received during that renewal. Consular officers who flag a case for additional review often do so because they cannot verify the issuing authority through standard database checks. Having paper documentation of the legitimate process you went through can accelerate administrative processing significantly. Step 3. Monitor the NVC and KCC portals consistently. The National Visa Center and the Kentucky Consular Center are the 2 administrative hubs through which DV case status moves before and during the consular interview stage. If your case is placed in administrative processing, you will see status changes reflected in these systems. Do not wait for them to contact you. Check your case status at minimum once per week during active processing windows. Step 4. Be extremely cautious of any individual or service claiming they can expedite your case, remove a 221G flag, or guarantee visa issuance in exchange for payment. This policy shift has created a new landscape for immigration fraud. Notarios, unauthorized practitioners, and scam services are already beginning to target DV selectees with promises they cannot legally fulfill. The only people who can legitimately represent you in consular proceedings are licensed attorneys admitted to practice in the United States or accredited representatives recognized by the Board of Immigration Appeals. Step 5. Consult with a licensed immigration attorney who has specific consular processing experience, not just general immigration experience, before your interview. The consular process operates under different procedural rules than adjustment of status proceedings inside the United States. An attorney who handles primarily I-485 cases may not be as familiar with the specific consular officer discretion standards and the documentary requirements that apply to DV cases processed abroad. Now let me give you the broader policy context because this change does not exist in a vacuum. This could affect you even if you're not a DV selectee. The passport verification cross-referencing system that is now being applied in DV processing is part of a broader document integrity initiative that the State Department has been rolling out across multiple visa categories since late 2025. While today's focus is specifically on DV-2027, the same passport issuance scrutiny is beginning to appear in certain family-based immigrant visa interviews and in some non-immigrant visa renewal contexts. If you or a family member is going through any consular processing in the next 18 months, awareness of your passport's issuance documentation is going to matter more than it did 2 years ago. This policy shift was not accompanied by a formal regulatory rulemaking process that would have required public notice and comment under the Administrative Procedure Act. It was implemented through internal consular guidance and updated officer training protocols. That has two practical implications. First, it moved fast, which is why many applicants and even some practitioners were not aware of it until cases began presenting differently in recent months. Second, it is potentially more vulnerable to legal challenge than a formally codified regulation would be. However, and I want to be very clear on this point, the timeline for any successful legal challenge to result in meaningful relief for individual DV 2027 applicants is almost certainly longer than the fiscal year deadline that governs those cases. Do not count on a legal challenge to protect your specific case. Protect your case yourself through preparation and documentation. Congressional interest in the diversity visa program's administrative processing standards has been episodic, not sustained. There have been periodic proposals both to expand and to eliminate the DV program entirely, and neither side of that debate has the legislative momentum to produce action in the near term. What that means practically is that the current policy environment, including the enhanced passport documentation requirements, is likely to remain stable through the DV 2027 processing window absent a court order. However, this protection may not be permanent, and in fact, the policy environment may tighten further. The State Department retains broad authority under INA Section 222 AF to withhold and modify the issuance standards applied at consular posts, and the history of that authority suggests that when document integrity concerns are identified, the administrative response tends toward greater scrutiny rather than less. If you are a DV 2027 selectee who has not yet had your interview, the window to prepare is now. If you are a DV 2028 hopeful, still waiting to learn whether you were selected, understanding this landscape helps you prepare your documentation now before you even know whether you will need it. I want to take a moment before we close to talk about what is actually at stake here, because sometimes in the focus on forms and deadlines and passport dates, we lose sight of what immigration status really means for real families. For a DV selectee, this visa is often the culmination of decades of dreaming about the United States. It represents family reunification, economic opportunity, educational access for children, and in some cases, freedom from political or social circumstances that made life in a home country genuinely difficult. When a case is lost to a procedural issue, an administrative flag, a passport documentation gap, a 221G that runs out of time, the emotional consequence is not abstract. It is a family sitting across the table trying to explain to their children that the life they planned is not happening. It is a spouse who gave up employment, or a family that sold property, or parents who said goodbye to their community, all in preparation for a journey that was stopped at the door by a passport issuance date that nobody told them to worry about. Immigration status touches every dimension of a person's life: employment stability, financial security, long-term residency planning, the path to citizenship, and above all, the ability to keep a family together. These are not bureaucratic abstractions. They are the things that make a life. And that is why accurate, timely information is not a luxury. It is essential. So to summarize what we covered today, USCIS and the State Department have implemented enhanced passport documentation verification protocols for DV 2027 consular processing. These protocols involve cross-referencing passport issuance dates and issuing authorities against a review system that can trigger 221G administrative processing. For DV selectees, a 221G that is not resolved before September 30th, 2027 results in permanent visa expiration under the non-extendable statutory deadline governing the diversity visa program. The appropriate response is immediate passport review, thorough documentation of your passport's issuance history, consistent monitoring of your NVC or KCC case status, vigilance against immigration scams, and consultation with a licensed immigration attorney experienced in consular processing. You have the information, now use it. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. If this video helped you understand something you didn't know before, please like it. It helps this factual, policy-based content reach the people who need it most. Drop your visa category in the comments below. I read every comment, and it helps me understand what issues to cover next. And if you know someone going through the DV process right now, a family member, a friend, a colleague, share this video with them today. You might be giving them the one piece of information that makes the difference between a successful entry and a heartbreaking rejection. Thank you for watching. Stay informed, stay prepared,